Good afternoon, everyone. I welcome all of you to the first Pro Bono Club lecture series. First, I would like to thank Senior Advocate Indira Jaising, ma'am. Thank you, ma'am, for accepting our request and agreeing to deliver a lecture. Second, let me convey the Vice Chancellor, Professor Sri Krishna Devarosa's message. He was very interested in attending this session, but Professor Rao has to attend a CLAT EC meeting, which is happening right now. So Vice Chancellor has asked me to convey regards to ma'am. And let me tell you the kind of active pro bono activities we are doing in Nalsar. Since the inception of Nalsar University of Law, we had some really good pro bono club activities which we are continuing. Our land life clinic was one of its kinds in India. We have trained various people, and they have actually spread across all the districts in the state of Andhra Pradesh, which is now divided into Telangana and Andhra states on land rights, and they have resolved like thousands of cases. We have like prison law clinic program, we have juvenile clinic program. We are doing all sorts of programs in Nalsar. Recently, as part of Pro Bono Club, we have also started the first training session for Agri Legal Aid Clinic program in India in Nalsar University of Law. Later, Agri Legal Aid Clinic has also taken very interesting cases which were faced by various farmers across Andhra Pradesh. It has also been spread across India right now. Now, also from Pro Bono Club, we are also with closely collaborating with State Legal Service Authority, Telangana State, and our students are being recognized as paralegal volunteers and working directly under District Legal Service Authority as paralegal volunteers, and also helping people with respect to their application forms and various schemes, spreading of legal awareness on various programs like menstrual hygiene, POCSO, women rights, alcohol consumption, government schemes, Consumer Protection Act, so on and so forth. We are doing all sorts of community care legal awareness, helping them with their enjoying in various schemes, enrolling them in Aadhaar cards or bank accounts, and all sorts of activities are being done under the Pro Bono banner. So for the first time, when it was mooted that we start an online meeting session with respect to Pro Bono Club, and Indira ma'am has kindly agreed to give us some her valuable time and give this lecture. Thank you, ma'am, for agreeing to it once again, ma'am. I request you to please deliver your lecture. We are all eagerly waiting to hear from you, ma'am.
Yeah. Before initiating, ma'am, if I may request to please introduce you formally. Good morning, everyone. My name is Harsh.gour, and I'm the student coordinator for this series. And I welcome you all to this inaugural session. And thank you, Ashwini sir, for addressing the session. Now, ladies and gentlemen, today we have with ourselves Miss Indira Jaising, and she's the guest for our inaugural session. She's a designated senior advocate at the Honorable Supreme Court of India. She served as an additional Solicitor General from 2009 to 2014. She has been an expert committee member of the Convention on Elimination of All Forms of Discrimination Against Women, representing India. She is the co-founder of Lawyers Collective, and she's also the co-founder of the Leaflet. Now, putting some rules for the session in place. The session will run for 1 hour, including 10 minutes for Q&A. All participants will remain muted during the session. Please use the chat box to type your question or raise your hand during the Q&A to ask directly. Now, I would request Indira ma'am to please deliver the inaugural lecture.
Thank you. First, I'd like to thank you for inviting me to be the inaugural session to this very important initiative that you have undertaken through your university, Nalsar. I have taken the liberty to share the link with HS University in Mumbai, with whom also I have an association where I'd encourage them to set up a legal aid center. And I think it's a good idea for universities to speak to each other across borders. That being said, as I said, I'm honored to be able to deliver this lecture. My endeavor will be, of course, to complete it on time. The subject is so vast that you will necessarily see me speeding down the line. Don't let that intimidate you. I'm assuming, obviously, that all of you have studied the subject of human rights before you have joined this lecture. So a lot of what I say will have to be taken for granted as already known to you. And then maybe the last 10 minutes, as harsh.gour said, we can have a bit of a discussion. So let me begin promptly without wasting time. Here's what I think. I think human rights are basic freedoms and entitlements against the state. Please note, I would like you to emphasize the words against the states. Ordinarily, human rights are not enforceable against private individuals. The origin lies in trying to rein in authoritarianism or monarchies, and hence they are necessarily entitlements against the state. Please be totally aware of this. There are exceptions to the rule as we go along. We will see them as mentioned in the Indian Constitution. What do they reflect? What are the values that human rights try to uphold? Quite simply, inherent dignity of every individual, and they aim to ensure that a life for freedom, equality, and justice. Now, of course, all of you, me, you, everybody, we take these things for granted. But history tells us that there have been centuries and centuries where the value of dignity did not exist, the value of freedom did not exist, the value of equality did not exist. You're all aware that history tells us that there has been slavery, there has been torture, and the value of justice. History also tells us that there have been periods when we did not have what we today call an independent judiciary. So kindly don't take these values for granted. As we go along, we will see that these values have been hard fought for. And as students, I would like you to pay homage to those who fought for these rights, often at their own life, and make a contribution to you. You have inherited these rights. They are yours to respect and to enforce. They are universal, they are inalienable, and they are interdependent. We will see what this means in a little while. But they are not all enforceable. Civil and political rights are enforceable, whereas social and economic rights are not enforceable. And as students of constitutional law, all of you know that this division between fundamental rights and directive principles does exist in the Indian Constitution. Let's move on. Here's the history that I would like you to be very, very cognizant of. And I would strongly recommend, if this lecture has any meaning in your life, that you go back and read these documents. So where does it all begin? 1215, the Magna Carta. The first major assertion that even the king is not above the law. Make a note of this. This is the origin of rights against the state. Guaranteed basic rights like protection from unlawful imprisonment. Habeas corpus is the remedy. We'll look at the remedy later. Foundations of the rule of law and constitutionalism. Now, I would like to just briefly alert you to the fact that the Magna Carta is not a perfect document. It made exceptions in relation to slavery. There were many other exceptions which today we don't accept, but it did begin what we today see in Article 21 and in many of the UN conventions. Let's move on to the American Declaration of Independence, 1776. It asserted that all men are created equal. Again, notice the use of the word men. It is a fact of history that women were not considered created equal in 1776 when the American Declaration of Independence were made. What did it say? It says all men are created equal in inalienable rights and the right to life, liberty, and the pursuit of happiness. You go to the 1789 French Declaration of the Rights of Man and the Citizen, again affirmed liberty, property, security, and reference to oppression. Now, all of you must be cognizant of the fact that all this culminates in the fundamental rights that you see in the Indian Constitution. I don't have time to discuss this, but I urge you to go back and read up the history leading up to the creation of fundamental rights in the Constitution. Now I'd like to point quickly to a controversy which is going on till today, and that is, are human rights inherent or given by constitutional law? Please note that this is, for you, going to be one of the most important issues which has practical implications as you move on to a career, not just a career, as you move on to being citizens of India. I mean, I know that you are already citizens of India, but as you move on to being engaged citizens, as you move on to being participatory citizens, this is one controversy you need to be aware of, and your future will depend on which side of the line you stand on. So be aware, be cautious, be cognizant, and do your reading. So what is the controversy? There are two ways of looking at human rights. One is to say that they are inherent, they are natural rights. That's known as the natural rights theory. Let's look at it a little bit. The argument of this view is that human rights pre-exist before any state came into existence and any legal system came into existence. They are derived from universal. Please emphasize the word universal. Universal moral. Is that a problem?
I request call-in user 1 to please mute yourself.
Yeah. So please, the moral principles, natural law, or intrinsic rights of human beings. This perspective suggests that governments do not grant human rights. Rather, they are obligated to recognize, respect, protect, and fulfill. Please note the words respect, protect, and fulfill, because you will find them recurring in international documents, and they are critical. They are subsequent developments. You will find them under protocols, under general comments in international law, and you will be able to understand what this means as you go along. Now, what is the implication of all this? It means that if rights are inherent, that no government and no law can take them away. And constitutions and laws merely articulate and provide mechanisms for the enjoyment and enforcement of these rights. Violations of human rights by a state are seen as transgressions against a universal moral order, and might I state also a constitutional and international legal order. It is in this context that we have the Universal Declaration of Human Rights, which we'll come to in a minute. Let's move ahead. This is the other view now that I'm presenting to you, and I said you as students must know which side of the line you stand on. Here's the other view. Human rights are granted by constitutional law, and this is known as the legal positivism point of view. Here the argument is that the rights exist only when they are codified in law, whether domestic, constitutional or not, whether international law or not. Rights are creations of legal systems and therefore subject to the will of the sovereign. Note, please, the use of the word sovereign. The word sovereign here does not stand for a king. It stands for a duly elected government in power which exercises sovereignty over a given national territory or by treaties. Now, what is the implication of this? If rights are solely creations of law, then logically they can be taken away or modified by law. And when we say law, we can, even in a democracy, you can say a parliament can enact laws. Of course it can. But the critical question is, can it enact a law taking away a fundamental right? And we'll address that in a minute. This view, in my opinion, poses significant risks, as it would legitimize arbitrariness in regimes, majoritarianism in decision-making, and it could suppress minority rights or even fundamental rights. Why minority? Why not majority also? They could also be suppressed. While international human rights law aims to create a universal law without the concept of inherent rights, these international instruments could theoretically be repudiated or ignored. I want to just make a point over here. I stand on the side of inherent rights, but I would like to make it clear that many people have argued that these inherent rights are given by a god. I believe it's not necessary to be theistic in order to understand that human rights are inalienable. They are inherent by virtue of being born into the species of human beings. And I hope that all of you are also aware that in today's world, there's an ongoing debate that these rights are not only inherent to human beings as Homo sapiens, but also animals and other creatures. We also have case law which has given legal standing and locus to things like rivers and now hopefully to climate. So none of these things really require a belief in a God who gives you these rights. I would like to put that on the table. Okay, let's move on. What exactly is international law? International law has various sources. It comes from treaties and conventions. It comes from customary international law. It comes from just cogence, which is customary non-derogable law. And some of the non-derogable rights under international law are slavery and torture, cruelty. Not enough time, I'm afraid, to discuss these issues, but very, very significant. Let me know. Harsh, can you please caution me about time? Okay.
Sure.
Now I come to the question of, you might ask the question, but why should we even bother about international law? We have our own national laws. Now, this is a myopic point of view for many reasons. First of all, the rights that you got came from civilization worldwide. Wisdom is not the privilege of any particular community, caste, or nation. As students and scholars, it is our duty to get wisdom from wherever we can. And a great source of wisdom is developments in international law. However, you might ask the question, is international law binding on India? And this brings me to the current slide. There are two ways of looking at international law. One is monism and the other is dualism. Monism assumes a legal system in which the minute you sign a treaty and ratify it, it becomes part of the law of the land. Dualism does not accept that point of view. Treaties are signed, treaties are ratified, but they become part of the law of the land only when they are domesticated in Indian law. And India belongs to this category of countries. It's a sovereign decision. You decide whether you want to be a monistic country or a dualistic country, and India has taken a call that we will be a dualistic country. United States is an outstanding example of the fact that it's a monist country, and this accounts for the fact that the US has not signed fundamental treaties such as the Convention on the Rights of the Child and, in fact, CEDAW, of which I was a member, which guarantees the right to equality and non-discrimination to women. You might even want to know that in the United States, there is no guarantee of non-discrimination based on sex. And women's groups have been lobbying for a very long time to get it into the Constitution and have not succeeded till date. Of course, this does not mean that they don't have statutory laws. They do have statutory laws which guarantee non-discrimination. Let's look at some of the key international instruments. There is the Universal Declaration of Human Rights. It's worth reading what it says. All human beings are born free and equal in dignity and rights. Though not legally binding, it is the foundation of global documents of human rights. Now, this is a declaration. It's not a treaty. It's a declaration made by several countries of the world, India being part of this declaration. So you can call this a document of values, a document on which all other human rights treaties are based. You have the European Convention on Human Rights in 1950, It's a legally binding regional treaty, articulates civil and political rights enforceable through the European Court of Human Rights. You have the International Convention on Civil and Political Rights, 1996. It has been ratified by India. It establishes binding obligations on states to respect the rights such as the right to life, equality before law, freedom of speech and assembly. And since we are talking about human rights and since we are in India, we need to note that the rights guaranteed by this convention have been incorporated into the fundamental rights in our constitution, which of course predates this convention. You can see this convention came in 66, whereas our constitution was drafted in 1947. Then you have the African Charter of Human Rights and People's Rights of 1981, which also integrates civil, political, and economic rights and places duties on individuals as well. In India, you have the Protection of the Human Rights Act 1993. Section 2D reads as follows: human rights means the right relating to life, liberty, equality, and dignity of the individual guaranteed by the Constitution or embodied in international conventions and enforceable by our courts in India. Please, many people tend to ignore this tiny little section 2D in the Protection of Human Rights Act 1993, but in a lecture on what are human rights, I would say you have the definition right here. It is an incomplete definition because it doesn't deal with social and economic rights. And you all know the reason for that. The reason for that is that in India, our directive principles are the ones which talk about social and economic rights. The right to fair wages, the right to health, the right to a proper environment, the right to development, the duty to advance the interest of weaker sections of society. It's all part of our directive principles of state policy, which I'm sure you have learnt are not enforceable in a court of law. So it is with good reason that Section 2D has confined the definition of human rights to the right to life and liberty. However, I think in an academic discussion, you do not need to confine your discussion to these rights. Where do we go from here? The dominant international consensus, as reflected in documents like the UDHR, leans heavily towards the inherent nature of human rights. This is why human rights are often described as inalienable. They cannot be transferred or surrendered. While national constitutions and national treaties give legal force to these rights, they are seen as affirming rather than originating from them. So, friends, I hope I have presented the 2 points of view very clearly, and you really, as students, as human beings, as citizens, as professionals, as scholars, as you move forward in life, you have to take a stand, which side of the line you stand on, because this debate is an unfolding debate. Let's now quickly move to the Constitution of India, because the Constitution of India is where you get all your rights from. So let's quickly go through this. India gained independence, as we all know, in 1947, ending colonial rule after a long freedom struggle. Constitution was adopted on 26th November 1949, which is why it's known as Constitution Day, and I'm pretty sure that in Nalsar you celebrate Constitution Day in your own way. Think about it. Why do you celebrate the Constitution of India? Ask yourself the question and answer it. Sometimes in law schools, these questions are not asked. And while on the subject, I can tell you on an aside and on a lighter note that your learning doesn't always happen in law school. A lot of it happens outside law school, which is why this pro bono club is so important, because it does take you out of your law school. Anyway, we move ahead. We have fundamental rights. We have part 3. We have the directive principles. We've already talked about this. So let's go to citizenship, which is really the reason for talking about citizenship, is to tell you that it is citizenship which is the binding element between an individual and a state. And rights are granted and duties are imposed on citizens. Many rights are not available to non-citizens. Some of them are, as we shall see. They are universal and belong to all humans regardless of citizenship. The scope, enjoyment, and enforcement of certain rights often depends on one's citizenship status without a specific nation state. I hope all of you are aware of that. May I continue? May I continue, please? Okay.
Yes, ma'am. Please, ma'am.
Yes. All of you are aware of the ongoing debates in India of the status of Rohingyas, refugees, now Bangladeshi refugees. India has not signed the Refugee Convention. And I hope you're all reading the news reports about the deportations that are being carried on of illegal immigrants. Of course, you've all also been reading about what's going on in the United States of America, where you have President Trump also dumping what he calls illegal immigrants into detention centers for eventual deportation. Now, a question for you to ponder: do these actions of various states violate the international regime of human rights? Are refugees not entitled to rights? We will deal with these. A little later. Let's just move on to the human rights guaranteed by the Indian Constitution. Again, I take it for granted that all of you have already studied these rights in your constitutional law class, but we will, for the sake of refreshing our memory, go through them again. The connection between citizenship and human rights in India is enshrined in Part 3, Article 12 to 35. Of these, the most important are the right to equality, which goes from 14 to 18. It guarantees equality before the law, prohibits discrimination on grounds of such as religion, race, caste, sex, and place of birth. The right to freedom, 19 to 22. Of course, it has been said that 22 is not a right, it's a limitation because it deals with preventive detention. The freedoms of speech, assembly, association, movement, residence, profession, along with protection of criminal matters. Right against exploitation, 23 to 24, very, very, very important. Please note the distinction. Prohibits human trafficking, forced labor, and child labor, and hazardous employment. If I'm not mistaken, this is also one of the horizontal rights of the Indian Constitution. For example, you are prevented from employing child labor, although you're not the state. You must remember this distinction because it is the right against exploitation. You're prevented from having a slave for that matter. And there is an ongoing debate: how does India treat domestic workers? We still don't have a national law which protects the rights of domestic workers, and there are major movements to include these rights statutorily across the country. In any case, some states have provided for minimum wages for domestic work. The right to religion. Just a minute. In addition to this, I would like to draw attention to Article 17, the much, much talked about Article 17, the right to be not an untouchable, the right against untouchability. Very highly debated right, especially put there by Dr. Ambedkar because of the existence of caste in India, which was attempted to be addressed and dismantled through this, amongst other articles of the Constitution. And again, this is a right which is horizontal. Again, this is a right which is applicable to us, though we are non-state actors. None of us can treat another human being as an untouchable. And if we do, there are laws to prosecute us. There is then the right to freedom of religion. Again, a very, very important right. But I'd like you to note it also includes the freedom of conscience. So atheists would be protected under this particular provision. Cultural and educational rights, very, very important. It protects the rights of minorities to conserve their own culture and establishes and administers education institutions. In my opinion, cultural rights also protect the culture of the majority, provided that culture or aspects of it do not violate any fundamental right. However, we all know that rights are not absolute, and all of you have learned about reasonable restrictions on rights. Yeah. Let's quickly move on to each of them. Article 14, equality before law, guarantees equality before the law and equal protection of law to all persons within the territory of India. Equality before the law is a negative concept, implying the absence of special privileges. Equal protection of laws is a positive concept, requiring the state to ensure equal treatment in similar circumstances. I would, however, like to point out over here that we have moved beyond these concepts of formal equality and gone into the concept of substantive equality. So in order to decide whether equality has been denied, we don't just look at the law, we look at the impact of that law on a given community. Is it a disparate impact? Is it an impact which goes beyond what it would on another group? And classical examples would be women and people with disability, or scheduled castes and scheduled tribes. So the classical doctrine of classification is encapsulated in State of West Bengal versus Anwarali. A law may treat groups differently. Here's the issue. Classification is based, but it must be based on intelligible differentia and must have a rational nexus to the object sought to be achieved. These are all basic principles which later come to be elaborated and made more specific in their applications, as you will see. I would like to draw attention to the latest in the series of judgments on Article 15, which came in Saira Banu, in which one of the judges, Justice Rohinton Nariman, articulated the theory of manifest arbitrariness. This has nothing to do with the doctrine of classification. And he said that if a law is manifestly arbitrary, then that law has to go. And on that basis, he did invalidate the practice of triple talaq. We don't have the time to talk about it, but you have enough to think about. Let's now come to Article 15. It's the prohibition of discrimination. It prohibits the state from discriminating against citizens only on grounds of religion, race, caste, sex, or place of birth, or any of them. 15.2 extends this to non-state actors. No citizen shall be denied access to shops, restaurants, public wells, roads. Again, the gift of Dr. Ambedkar. Article 13.3 permits the state to make special provisions for men. I would say again, the gift of Dr. Ambedkar, which ours is a unique constitution which allows for not only for affirmative action but also reservations, as we will see. So there you have it, affirmative action in our constitution, which is enabling. State of Madras versus Champakam Dorarajan struck down caste-based reservations. Ashok Kumar Thakur sustained affirmative action in relation to reservation for OBCs in educational institutions. The range is very wide, and as students, you need to get into more detail. You need to get into your case law. You need to formulate examples and say, in this given set of facts, how would I use the Constitution? How would I apply it? Let's move on to Article 16, a very, very important and unique provision of the Indian Constitution. which is equality of opportunity. But equality of opportunity cannot arise by saying only that there shall be equality of opportunity. What the article actually does is make reservation in favor of scheduled caste and scheduled tribe. And as we move down the journey of affirmative action in India, in Indira Sawhney, we also got reservation for the OBC up to 27% by a court decision because of a memorandum which was issued in 1993, the constitutional validity of which was upheld. Please remember that the debate on reservation in India is a very critical and important debate. There are those who are aggrieved by reservations and those who are benefited by reservations. But if you need to go to your fundamentals, you must ask yourself the question on what is reservation based for scheduled castes, scheduled tribes, and other backward classes. It is based on the historic existence of the caste system in this country, which was intended to be undone by giving equality of opportunity. So equality of opportunity doesn't fall from the sky. It doesn't fall from a constitution. Law is how law does. And this is how we have done it in India. You all know that currently there has been yet another constitutional amendment which seeks to introduce reservation for women in Lok Sabha and all other elected bodies, which has not yet come into force. So reservation is an issue which has come to stay worldwide. In some countries, it's in relation to political institutions. In other countries, as in India, it's in relation to employment. I know the next slide is about Article 17, but I already dealt with it. So with your permission, I'll skip over it. The information is there for you. We come to a very important right, the right to freedom of speech and expression. Now, again, I'm going to run through this because you all know it. All I need to tell you is that, like all other rights, our Constitution has rights which within them contain reasonable restrictions, quote unquote reasonable restrictions. So obviously the debates are all going to be what is reasonable and when does a restriction cease to be a restriction and become an extinguishment. These are the two issues that you will have to deal with as students. Now, one of the most restrictions on the right to free speech, which you are witnessing today, is based on what they call the sovereignty and integrity of India and the security of state. All the debates in India on free speech today are around this issue. FIRs are very liberally filed against cartoonists, against YouTubers, that brings in the whole importance of the medium of communication of free speech, which is now changed from print to digital. We don't have the time to go into this, but one of your coordinators, Harsh, is a regular writer for the Leaflet on law relating to technology, and I've repeatedly pointed out that law relating to technology raises the most critical issue on the question of freedom of speech and expression. To what extent is our freedom of speech and expression curbed by the curbs that are put on us in the name of sovereignty and integrity? Apart from laws, there are statutes. We have in India the Unlawful Activities Prevention Act, which came way back in 1976. But that is not the end of the story. We also have a law which is just now passed in Maharashtra, the Public Security Act of 2025, which not only gives them the right to ban unlawful associations, but also civil society associations who, in their opinion, are impacting sovereignty and integrity of state governments. So I think it's an issue that you as students need to consider very seriously. What is our understanding of sovereignty and integrity of India? When can we say it is attacked? Is there a dividing line between attacking the sovereignty and integrity of India and legitimate dissent? And to what extent do our statutory laws prevent us from exercising free speech? Ample case law. Kedarnath is a brilliant example, outstanding example, where the validity of Section 124A of the IPC was challenged. The sedition law, as you know, sedition law has been kept in abeyance by the Supreme Court, but has been reintroduced in a new avatar in the newly enacted BNS. I'm not aware whether the new avatar has been challenged, but I'm sure it will be. I consider to be the new avatar even more draconian than the earlier one, because it adds into the picture, apart from disaffection towards the government, the whole issue of sovereignty and integrity. So now we have multiple laws dealing with a threat to sovereignty and integrity of India. But let's remember the dividing line in Kedarnath. It was that speech which encourages violence and is likely to lead to violence, and that which is not. These two types of speech have to be distinguished, from which will lead to the conclusion that legitimate dissent is very much part of our constitution. I don't have to agree with every policy the government of India enacts. I don't have to agree with everything they do, but my disagreement has to be decoupled from any form of violence. And if it is, then my speech is legitimate speech. But you see for yourself, nowadays, you will hear arguments which say, oh, well, you ban this particular movie or this particular speech or arrest this particular cartoonist because he has hurt the sentiments of a particular community. That's wrong. That's unconstitutional. The Constitution only recognizes the distinction between violence and non-violence. Remember, we are a country founded on the principle of non-violence, and we respect non-violence more than we respect anything else in this country. But what's going on today is for you to ponder about. Then there is public order, which is akin to the sovereignty integrity argument, because any threat to sovereignty will lead to a disruption of public order in the name of protecting public order. We've had internet shutdowns, but of course you're aware of the Shriya Sangal judgment, which upheld the right to free speech and gave us a lot of rahat, time to breathe, space to breathe, to be able to think and say what we want to say. I do not have the time to take you through the details of morality, contempt of court, defamation, and incitement to offense, but basic argument that you need to understand is the dividing line between violence and non-violence. I think it's very critical. You have again the right to association. Again, I'm going to skip it over for the reason that we are running out of time and there are some important issues remaining to discuss. But let me tell you that the right to association is a very valuable right. We live by association. As human beings, we cannot survive as individuals. And our associations can be any type of associations, families of our choice. We determine our own sexuality. We choose our families, or we are born into families. We choose the communities that we would like to associate with. We have neighbors with whom we live in harmony with each other. So the right to association, and you can go on like that till you start associating with the whole of humanity. Okay, that is ultimately the universal principle, and this is why you should safeguard your right to association very, very carefully. You want to associate even with animals, you should have that right. So look into the case law. It's mentioned there in the slide for you. One case stands out. Justice Markanda Karju in 2011 has said that belonging to an unlawful association, so-called, cannot be an offense. There has to be activity that you do. This was overruled in Anupuyan in 2023. You please have a look at that case. It is a rather dangerous case. You have laws like FCRA which prevent you from funding. Or unfortunately, if you want to do any human rights work, you might want funding, whether it's foreign or non-funding. And so the whole issue of economic sanctions becomes a restraint on free speech. I'm going to really rush through because the right to life and liberty in Article 21 is something we all know. What I would like to take you through is, of course, please be aware that Article 21A was added as an additional fundamental right, the right to education, and a very important one. What I want you to understand is many of these rights have come via court judgments. I also want you to understand that some of the rights ultimately do collapse the difference between civil and political rights and social and economic rights, because ever since Francis Moulin, when the Supreme Court said that life is not animal existence, we've had an expanding frontier of rights. We've included education, we included health, we included environment, we included now climate change. Let me come back to the controversy I raised earlier. Which of the two views you believe in? These are reflected in two cases of the Supreme Court of India. Keshavananda Bharati, which came in 73, and ADM Jabalpur came in 1976. ADM Jabalpur is the outcome of a theory which believes that rights are given by law. And what a constitution gives, it can take away. Is what ADM Jabalpur was based on. Whereas Keshavananda Bharati was based on the understanding that the Constitution exists to protect rights and not to create. Very important. Something to take away, something to think about. And the next slide also only talks about these two visions, so we can skip them over, but ponder over them. And then you come to, I think we've reached a stage we've done actually with civil, political, and economic and social and cultural rights. If you move forward to rights extended by case law, this is what I meant. I told you, let me talk about Olga Tellis, a case which I argued way back in 1985, which resulted in the right to housing, at least an incipient right, if not a complete right. Rural entitlement minimum wages led to the grant of minimum wages to agricultural workers. MC Mehta established the right to clean air and environment. You have Godavarman, which protected the forests against undue exploitation, and now we are moving towards climate change. So some of these ultimately get put into statutes. They come to statutes via case law. So you have the Right to Education Act of 2009, you have the National Food Security Act of 1931, you have the Mahatma Gandhi Rural Employment Guarantee Act, and there are many more. There is the Street Vendors Act, which came as a result of Bombay pursuing judgment. Quickly to remedies. Remedies, I don't think you people need much telling. The remedies are found in statutory law in Article 226 and in Article 32. And now, towards the end of this presentation, we come to the issue of origin of public interest litigation, which links with your pro bono club. So just remember that it was Justice Bhagwati, of course, Krishnar, and many other judges who pioneered the idea of public interest litigation to open the doors of justice to those who were disadvantaged, marginalized. Please underline the words disadvantaged and marginalized. And in theory, the theory was that they cannot approach the court to get relief for themselves. How will an illiterate person approach a court? Take the example of the Bhagalpur blinding case. The Supreme Court took cognizance of news reports published in the Indian Express where blinding was used as a form of punishment. That really is where it all began. And then you have a whole host of case law, which I've already told you about. But don't ever forget that origin of it was to enable marginalized communities to approach the court through non-state actors, through aware citizens, and other such agencies. Let me come finally to practicing human rights law, pathways within the legal profession. Human rights law is not a niche, it's everywhere. Many otherwise perceived to be ordinary legal matters, bail, eviction, prison conditions, discrimination, raise fundamental human rights issues under 14, 19, and 21. If you choose to practice criminal law, you will have to know your human rights. You don't need to work as a human rights NGO to practice human rights law. Any court, any client, any case can be an opportunity to advance justice and dignity. Please remember that as you move on in life. I've written a short piece for myself elsewhere in which I have said every morning when I enter a courtroom, I ask myself the question, why am I here in this courtroom today? And the only answer which I give to myself is because I'm looking for justice. So that is something I do not want any of you to forget. Every time you enter a courtroom to argue a case, ask yourself, why am I there? Now, obviously, you're also there as a professional. You're also there because you want to earn your living. There's nothing wrong with that. No one is saying, please do pro bono law all your life. Okay. You can integrate your pro bono law with your existing practice, but more importantly than integrating pro bono, integrate human rights in your paid work. That is my message to you. There are different ways in which you can do it. You can do pro bono work and PIL. You can be a panel lawyer. You can be in legal aid services. You can be in criminal law and bail and advocacy. You can do civil liberties and constitutional litigation. You can do documents and affidavits. You can do legal opinions. You can do research. You can do strategic and support litigation. I'd like to end here and thank you for listening to me. Thank you.
Thank you very much, ma'am. I think now we can take a few questions. So participants, please, anyone can please proceed.
Good
May
afternoon,
I?
ma'am.
May I ask a few questions? I'm Sairam.
Yeah, please, Sarah.
Hello, ma'am.
Yeah.
Ma'am, please ignore my lack of depth in the subject. But my question is that can we treat human rights violations equivalent to that of crimes, based on the definition that crimes are serious wrongs which affect not only individuals but also the society at large, and human rights violations are also, though affects individual, they can be considered as a violation against humanity at large, no ma'am?
I agree with what you say, but I don't understand your question. I don't see a question over there. What is the question to me?
The question here is that when the human rights violations taken up, when they are turned into criminal cases, they lose their human rights perspective in the proceedings, no ma'am?
I don't get you. I can only tell you that there are many, many cases. Take the FIRs which are filed against, let's say, a cartoonist who has done a cartoon, okay? When you go to court representing that cartoons, how do you see yourself? Do you see yourself as arguing a human rights case or not? If you see yourself as arguing a human rights case and you invoke Article 19(1)(a), how would you shape your arguments? You would say there is a right to free speech. You would say that this particular cartoon does not violate the right, it cannot be restricted because there's nothing in it which falls within the reasonable restrictions mentioned in Article 19, and therefore this whole affair should be quashed. So this is what I mean when you say, remember, they are invoked and available against the state, except the few rights which I told you about.
Thank you, ma'am.
Good afternoon, ma'am. I wanted to ask, at the risk of the question being very superfluous, do you draw a distinction between human rights and fundamental rights?
Okay. I thought I made it clear, but I did not. So the answer is what is universally called human rights under the Indian Constitution is called fundamental rights. Now, so therefore, the question answers itself. The issue for you to consider, however, is two things. Are all universally accepted fundamental rights part of India's constitution or not? Which are the ones left out? Second question for you to consider is that the kind of restrictions that have been put on our fundamental rights, are they restricting fundamental rights or are they taking them away? And the third question for you to consider is, although this sounds so beautiful on paper, what is India's state practice? These are the three issues that one needs to look at.
Thank you, ma'am.
Good afternoon, ma'am. I had a question pertinent to the natural rights theory. Ma'am, in a complex socio-economic and politically varying as well as socially binding differences, as we observe in the Indian context, ma'am, how do you interpret the international law in this context? Do we need a monoism approach in order to, have a progressive form of jurisprudence, or do we need our own dualism approach that we are already following? Thank you.
Thank you for that question. It's a good question. The answer can be quite complex, but nevertheless, it has to be answered. So I would say that yes, we live in a very, very complex world, and we need to actually question the nature of the functioning of our democracy. But that apart, on the specific question of monism and dualism, I can only tell you the advantage of dualism as opposed to monism. I've told you that the United States has refused to sign the Convention on the Rights of the Child and CEDAW because they are monist. On the other hand, India has signed both those conventions. Okay. Now, why did they sign them? Because very conveniently, we are a dualist country and we will still have to incorporate them into our national laws. But there is an advantage to dualism in that we can shape our own domestic laws. And let me tell you that a lot of these laws that have come into existence, you must know that, have come through great deal of lobbying. So by civil society. And when I say lobbying, I mean not lobbying really, struggle, movements. Study the movement for right to food campaign, which went on for more than 30 years before we got a law relating to food security. Patent laws is a great example of how dualism can be better than anything else. Of course, we have signed WTO, but we have exceptions. And we've been able to develop our own generic industry. So there are advantages to dualism, which gives more agency to citizens within the state to be able to lobby for their own demands.
Thank you, ma'am.
Good
Good afternoon,
afternoon.
ma'am.
Yeah,
Yeah.
we'll surely take your question, but we have some over the chat box. Ma'am, I would like to just read a couple of questions here. Vineet Pratap Singh is asking, there is a strict guidelines by the Supreme Court to stop sand mining in Rajasthan, but the administration, including police, is not stopping it, leading to excessive exploitation of Aravalli range. Should NGT be prepared or review petitions?
Should NGT be what?
NGT, the probably the Green Tribunal, be prepared or review petitions.
Oh, okay. Are you talking about like a choice of forum? You must use every forum available to you, and there are advantages to approaching an NGT. Expert evidence can be led, which is generally not done in a high court or in the Supreme Court. So, depending on your local situation, please use the NGT.
Then there's another question. Shiva is asking, as a young advocate planning to start a pro bono legal trust in rural Telangana, what initial challenges should I anticipate and how can I build sustainable impact from the ground up? What essential legal and administrative structures should I set up while forming a pro bono initiative or trust?
I'm sorry, is the question that he's planning to get into a law practice and wants to know what is the necessary tools for the way forward? Is that the question?
Ma'am, I think he's asking about the structure, the legal and administrative structure, and intending to start a pro bono initiative.
I just told you that you don't have to worry about questions like that. I just told you that pro bono work can be integrated into any work you do. If you want to do only pro bono work, then there are lots of NGOs doing pro bono work. As I told you, on issues like right to food, on issues like to employment, on issues like domestic labor, on issues like fair wages. And if you want, you can get attached. The PUCL is there. You can get attached to any one of these organizations. It's a very personal choice. I cannot recommend anything.
Yeah. Now I would like to request Ashwini sir to please conclude the session.
I'm sorry, but can I just ask one more question?
I think it's fine. Just let her go ahead.
Yeah.
Thank you, ma'am. It was a wonderful session. I just wanted to know that specifically as a country like India, how can we ensure that international human rights standards are effectively translated into national laws and practices and more accessible to vulnerable and marginalized groups as we discussed in the session?
Yeah. Ma'am, there are no shortcuts to this. I have been part of, I wouldn't say I've been part of movements, but I've been associated with very many movements, okay? I think you should study how the Right to Food Security Act came about. You should study how NREGA came about. Maybe you should teach this in your pro bono clubs, document the history. What I'll do is I'll try and get some of the literature from them and share it with you. But the answer to your question is really that, you know, the marginalized communities stand up for themselves. One of your previous questions one of the previous questions was about the complex social and economic structure that India lives in. India lives in a form of extreme monopolistic capitalism. Okay, and these are the people who don't necessarily care about marginalized communities. So the only answer to your question is marginalized communities organize and stand up for themselves. That's why I told you the right to association is so important. But let me tell you, the law is a very important tool in your hands, and you are in a law college. Please use it.
Right, ma'am. Thank you so much.
I think participants, in case of any questions have been left unanswered, you're welcome to email us your questions and we'll try to get them answered. Now, ma'am, I would request you to please, if you have some concluding remarks.
It's been a pleasure being with all of you. I'm so sorry that I cannot see all of you. I would have loved to, see each one of your faces, but I know that's not possible online. I generally prefer to have a kind of a human touch and a human communication with the people who I'm speaking with. I hope this has been helpful to you, but I can only leave you with the thought that I do think that there's quite a large army of young people today who are committed to human rights and who want to work for marginalized community. And I think it's the responsibility of universities such as yours to make that available. Maybe you should have a counseling session, or you should have some kind of a bridge with NGOs, which will enable these people to get either recruited by NGOs or placed with NGOs, and then let them take their life's decisions. No one has a right to take a life decision for someone else. They will take their own decisions, but I am very confident that there are many young people who are taking the right decisions. Thank you so much for this opportunity.
Thank you very much, ma'am, for being generous with your mind and kind with your wisdom. And I'm sure that this session will not end here and it echoes will stay with us, gently reminding and quietly teaching. Now I would request Ashwini sir to please conclude the session.
Okay, good afternoon, everyone. I am honored to deliver the vote of thanks on behalf of Pro Bono Club. I want to express our sincere gratitude to Senior Advocate Indira Jaising ma'am for her sharing her insights. And I also like to thank all the attendees and participants for taking time to be here with us today and engaging it through chat and also asking questions. Yes, I am sorry, we don't have enough time to respond to all of you. But I believe that we will have even more opportunities in the future where can be able to have even more conversations. Thank you, ma'am, and thank you, everyone.
Thank you for your